Welcome to What You Really Want to Know. I am attorney Amanda Shaffer. Today we are going to talk about some of the changes that are coming to the immigration courts that have been announced. Before I get to that, I want to remind everybody out there to like us and follow us on Facebook and Instagram, Twitter, LinkedIn, subscribe on YouTube so you don't miss any more of our lives. And hopefully I got the Instagram live working today. And if I did, welcome to our Instagram followers. So what's this all about today? Well, back in December, the Executive Office of Immigration Review, or EOIR, issued a memo in order to enhance case flow processing. And it's a known problem in the immigration court system that for years we have had really, really long backups. Just so many cases pending, not enough time, people waiting on average 2-3+ years before they can complete their case. And then the COVID-19 hit and really ate into the backlog, I should say, added to the backlog. And if you are in certain areas of the country, like in New York City, and you're not detained and you're in removal proceedings, you may know already that the immigration courts here have been closed now for almost a year, since last March. And there's a good chance they're not going to be opening anytime soon. Now, a lot of other courts around the country are open right now, but they're operating in a lighter capacity, and there's a lot of closures anyway for cleaning and COVID problems. Point is, we got a big problem that they're trying to address right now, which is this backlog of cases. So they issued this memo about how they are going to cut down on having to bring people into the courtroom. And there's some very important things here for us to keep in mind. Now, first, keep in mind this one thing. If you're watching this and you have court in anywhere, if you're not detained and you have court anywhere but New York City, then right now this doesn't apply to you. However, the intention is that this will expand to other courts. I think New York is one of the most backed up courts now, especially considering how long it's been closed. So we're going to be trying it out here first. Hopefully it works. It really will make things easier because it requires a lot less in-person court appearances. And I'll explain how and if you'll qualify and what you can do to qualify. Essentially, you need to have an attorney representing you. If you don't have an attorney, maybe one day they'll be able to do this for you as a pro se litigant. But at this point, it only applies for people represented by attorneys. And in order to not have to appear in court, your attorney needs to file what's called a Form EOIR 28, which is the Notice of Attorney Appearance, with the court at least 15 days in advance of your first hearing. If that happens, the court will vacate your hearing. But, and this is a big but, because everything I say relies on communication from the courts. If you do not get a notice saying your court was canceled, then you still have court and have to show up, and so does your attorney. But we'll assume, for argument's sake, that this is all going to work as planned. So we can actually file EOIR 28s online now, which is nice. So you file it online at least 15 days in advance, and then instead of having to attend in person or even on the phone, what will happen is the judge is now going to send out a scheduling order. But before I get to that, let me just explain how it works right now, normally in the courts that are open. You first, in order to get into removal proceedings, you get a charging document called a Notice to Appear in Immigration Court. And on that document, it lists why the government believes that you are not in the country legally and that they can kick you out of the country, basically. It says that you're not a native and citizen of the U.S., this is when you entered the U.S., this is a type of visa, or you didn't have a visa when you entered, and either you've overstayed, or you've committed a crime, or you lied, or whatever the area of law is that they're charging you with as being able to deport you from the country. When you get that first charging document, either you're going to have a date on the bottom for your first hearing, or you're going to get a hearing notice in the mail after that. Either way, you have your first hearing called a master calendar hearing. And master calendar hearings, anyone who's been in immigration court watching is familiar with them. Basically, there are a lot of people in one room. That's kind of why it's a problem with COVID. But, you know, it's kind of like this. You go up there for 10 minutes with the judge. Your lawyer says a bunch of things, and then you get a new date. Maybe you handed an application. That's a master calendar hearing. Depending on the case, you can have one master hearing or multiple. When things go right and there isn't certain types of issues, on average, you have one master hearing. You get your individual hearing. Your individual calendar hearing is your merits hearing or your trial, in a sense. That's your final hearing. And that's where you do your testimony, you give your, you introduce your evidence, basically tell the judge why they should not deport you and why you have a legal way to stay in the U.S. So they're trying to cut out now the first type of hearing, the master hearing, that short one. Although it's a short hearing in terms of how long you're in front of the judge, it is not short in terms of how long you wait to see the judge, because you'll have 50 people on that list for a morning. So it could, if you don't get there, I would get there at, court opens at if the judge started at 8:30, I'd get there at 7:30, just so that I didn't have to wait for 3 hours to see the judge. It was first come, first serve, that's why. So that was the old system. And like I said, in New York City, and there are a few other places in the country, we haven't had that at all since last March. We've just been closed. So the way they're going to do it now is at least 15 days before the master calendar hearing or the first hearing is scheduled, your attorney's going to file an EOIR 28. And that's going to tell the judge that you have an attorney, and then the judge will reach out to the attorney, say, okay, you don't have to come in person to the hearing. Here is a scheduling order. And they will also send the scheduling order to the government attorney, to DHS. In that scheduling order, you have to do a set of written pleadings. And what that is that charging document I told you about, where it says that you're not a US citizen or national of the US, how you enter the country. You basically have to admit or deny those. So not a citizen, national of the US. Yes, I entered with a B2 visa in December 15th, 2010, whatever it is. Your attorney will obviously help you with that, but you essentially say, yes, admit, and then you concede removability. And what that means is you're telling the court, okay, you're right, I don't have lawful immigration status. And with very few exceptions, that's the way every hearing generally goes for these master hearings. And that's because unless you are actually a U.S. citizen or wrongfully put in proceedings, if you're here at all and you don't have legal status, you can be put in removal proceedings. So you submit these written pleadings, and this is what you would, when I said earlier that, I think I said earlier that your attorney might waive readings of things at the master hearing. This is one of the things the attorneys always waive. We don't make the judge read the charges. We know what they say. We know what they mean. We just say, Judge, we admit allegations 1 through 4 and concede removability. Or we admit allegations 1 through 4, deny number 5. This is when they entered. Here's the proof. Concede removability. I think only one time, a handful of times, I didn't concede removability, and that was because one time a client was actually a naturalized U.S. citizen. So generally speaking, this is what happens. You also then either designate a country for removal or decline. If you're applying for asylum, saying I can't go back to my country, then you decline respectfully. So that's normally what happens at the master hearing, and then the judge will, if you have an application, you hand it in. If you don't, the judge may give you another master hearing to hand it in or schedule the individual and give you deadlines. So the new system says that we're going to send you the scheduling order. You'll do your written pleadings, and in the scheduling order, it's going to give deadlines for the filing of these written pleadings, plus deadlines for filing evidence related to the charges of removability. So again, that means if you're challenging what they claim about how you entered the country and why you're here illegally. Some people, sometimes you do, sometimes you don't. A good example is someone who entered, it said they entered without inspection at an unknown place or an unknown time, but that comes to me and says, hey, I entered with a visa. Well, then we're denying that charge and we're proving to them they entered with a visa, and that's the evidence that we're going to submit. So then we also get deadlines for when to file applications and any other relief or protection from removal. With the scheduling order, the judge is also going to send out instructions to do biometrics. These instructions will be for you and for DHS, because you have to go do your fingerprints and DHS has to run your fingerprints before the judge can do anything. So it's very important to always comply with biometrics. And then they're saying they're going to give, I think, 45 days from the day of that your hearing initially was supposed to be, or the day that they're vacating it. I'm not sure what they said, the date of vacated hearing. So I guess the date it was originally scheduled to submit these written pleadings. So I file an EOI 28 15 days before. I get my appearance waived. I get a scheduling order. And from the day that I was supposed to be in court, I then have 45 days to submit written pleadings, applications, evidence contesting removability. I'll have another deadline, which I'll talk about in a second, but basically that's what the scheduling order is going to tell you. If you do not submit applications and evidence by that deadline in the scheduling order, then you're waiving these applications and admissions of these documents, and you're probably not going to be in the best situation. So it's very important to always abide by the deadlines. And I will also say this, that the immigration judge has discretion to issue additional deadlines, allow you to submit additional applications. But again, you can't rely on any of it. They don't have to do anything. So you get a deadline, you have to follow the deadline. Once all of that is received by the immigration judge, within the 45 days, of course, then your individual or merits hearing will be scheduled. That will be in person still. That appearance cannot be waived. And with your notice telling you when you have your next court date, you will also get more deadlines. You'll have deadlines to your final evidence submission, any other applications. The judge may require a brief or a motion on certain legal issues that your attorney is going to have to file by a certain date. And it also tells the Department of Homeland Security attorney, you guys have your deadlines to reply to things or submit any evidence that you may want to submit in this case. And this applies to witness lists as well. And it also, just like the biometrics I mentioned earlier, will then additionally instruct everyone to comply. In the event the immigration judge makes a decision on your case before your individual hearing date, which at this point, we don't know how likely that will be. Like if you have a really strong case, it is, I guess, possible the judge can decide it just on the papers, or it's a different type of decision, then that individual hearing will be vacated if you have a decision beforehand. And this also means that they are going to be encouraging your attorneys to work with the Department of Homeland Security attorneys in order to come to agreements on things and file joint motions. So it hopefully will benefit our clients that DHS will be more likely to agree to grant relief, because we're not going to really agree not to grant relief for our clients. But there are certain things like voluntary departure, pre-terminating an application, withdrawing your application for admission, things like of that nature, that those generally are more of joint motion type things, and that should make it so you don't have to return to court when you file that. So basically, it's really going to hopefully streamline a lot of the process at immigration court. It requires a lot less appearances, and what the hope is that means that the individual hearings that right now we have clients scheduled 4 years out will get moved up, because the judges spend, I don't know if it's half their time or more than half their time at master hearings, but it's a lot. And if they're not having to sit there through the entire day conducting master hearings, that's obviously more time for individual hearings. But on top of that, they're also encouraging things to be settled out of court more, which really wasn't a thing in immigration court that much. If you watched our What You Really Want to Know yesterday, I talked about some of the other changes the Biden administration has already introduced and what we're looking at in the future to happen. And one of the things we're waiting on is more guidance about what they're going to do with all these backlog of cases, if they're going to close cases again like they did under Obama, or if they're going to terminate cases where they just don't have the resources to prosecute. We don't know that yet, but we do expect them to have more guidance in February, and that should also tell us how they're going to handle this backlog in terms of who they're going to focus on more. Where this is just about case processing, the flow of case processing. So it's going to start in New York, and I assume if it works well, it'll expand to the other courts. New York courts, we're actually, a lot of New York practitioners are very worried about what this court is going to be like when it reopens, because it's never been closed this long. It already had a historic backlog of, I don't even know, hundreds of thousands of cases. And now I can't even imagine. I've had so many cases canceled this year and then rescheduled and canceled. And the rumor is that there's a good chance that the immigration courts in New York City will not be reopening before the summer. So this is their attempt to kind of fix that. So to sum up what I talked about today, if you ever were thinking, maybe I don't need an attorney in immigration court, I would have always advised you to get an attorney, but now you're going to save yourself court appearances, which is nice. It makes everything a lot easier for your attorney to have all the deadlines in front of them, be able to, not have everything so attenuated. Like before, it was like you had one hearing and then you didn't see the client for 3 years, and we send letters telling to send us stuff, but people disappear. And then they come back like a month before, and then it's already, we miss our deadlines. Or we don't miss our deadlines, but we never miss deadlines. But it makes our job a lot harder. So this hopefully will make it a lot easier. It's possible we'll end up doing a lot more briefs and motions than we used to have to do, because the judges, we don't do those automatically. An example of this would be if you have a 1-year issue, and that means if you applied for asylum, you have to apply within a year of entering the U.S. to be eligible. There are very narrow exceptions to this rule. It's called the 1-year rule. And generally speaking, the judges want the attorneys to brief these 1-year issues. But if you walk into court and you have a solid argument and you have solid evidence, the judge might not need you to brief it, because then you can get the Department of Homeland Security to agree and save a lot of time writing a brief. But without being able to be in front of the judge, that might be a requirement. Other things that we're going to have to look out for is that a lot of times you go to immigration court for these master hearings, and they're almost like conferences or problem-solving conferences. Anytime there's an issue, and these things are never perfect. Half the time I go in there's something I'm fixing for the client that the government messed up. So it will be interesting how we end up dealing with that. It'll also be interesting to see how the communication is, because that's really the big thing. The courts have to get us these notices in time. They say 45 days. That worries me. 45 days from the date of the vacated hearing means that I'm not going to have my schedule. I might know, okay, 45 days, but I won't have the scheduling order yet necessarily. There are plenty of times where clients come to us and they know they got a notice of hearing, but they never got their notice to appear. So we don't know what the charges are. So we can't do the written pleadings. So there's a lot of questions that are up in the air right now. On February 11th, I'll be attending a stakeholders meeting with EOIR to find out more information about this and what to expect. I will do a live after that to pass on the knowledge that I gained and let you know if I think what I think of it. I mean, do we think that this is going to work? And is this going to make our lives easier, or is this going to make my life a lot harder? The goal here is to make it easier and the judges' lives easier, and I hope it does. But it's gonna probably take a while before we all settle into the new system. But again, if you don't have an attorney, you're gonna need to go to court. You're gonna prolong your case. You're gonna make your life harder, and you're also a lot less likely to win in removal proceedings without an attorney. There are statistics online that you can look up, and they're actually pretty shocking, but that's because immigration law is so complicated. So if you, we have comments. I'm sorry, guys. I wasn't even looking at the comments. Hi, Alvarez. You received fingerprints. Here we go. From I-45 and I-360. What are mean by fingerprints is for VAWA. Oh, that's an easy one. Not really related to the immigration court, but that's okay. All that is, Alvarez, is you need to go and get your fingerprints done. You should have gotten a notice that said that gave you an appointment at like a biometric, what are they called? Applicant Information Center or something. I don't know what they're called, but it should have a date on there and a place on there and a time on there. You take that notice, you go do your fingerprints. The reason they want to run a background check on you. Make sure you don't have criminal history, make sure you're not a terrorist or anything, or a threat to national security or public safety. So that's all that is. That's completely normal, Alvarez. Everyone who files these applications in I-45 and I-360 have to also do their prints. I think that was all the questions, at least that I can see right now. So if you do have any other questions about this or any other immigration issue, our contact information has been scrolling across the bottom of your screen. Please feel free to contact us. We'll be happy to help. And again, check back here in February after I attend my stakeholders meeting. I will be more than happy to provide more information. And I'm very hopeful that we will get our cases started again and get people's lives moving along, because I know clients are real frustrated right now. They're waiting to get their legal status, and it's kind of like they're in limbo. So I feel for all of you, and in New York and anywhere else in the country that has been halted for this long. But the good news is they are working on a plan. This is the plan, and you know what? I think it should be a good plan, because, like I said, it takes a lot of time to go to court, and it takes a lot of time off the judge's calendar that they'll be able to focus on other cases. And a lot of these matters, you just don't need to be before a judge. So I'll let you know more about that when I do. That is all for now. Make sure you like us and follow us on Facebook and Instagram and all those places so you don't miss another live. That is all for what you really want to know. Thank you all for watching. I will see you tomorrow.